Hi everyone, I am Karja from Sorainen law firm, and I am today talking about bankruptcy tips for businesses. I hope that during today's presentations you will get a quick overview about the main issues which are related to bankruptcy proceedings and also reorganization proceedings. If you have any questions, then please feel free to ask them afterwards. You have the possibility to write them down. Next to my presentation, there should be a box or a gap where you can write them, and then afterwards I see your questions and I can also answer them. Today's presentation is going to be approximately 20 minutes long, and I hope you will enjoy today's presentations. So, if we talk about bankruptcy and reorganizations proceedings, then it is very, very important to differ between temporary and permanent payment difficulties. There is no definition for temporary payment difficulties, but there is a definition for permanent payment difficulties. And when we are talking about permanent payment difficulties, we are actually talking about insolvency. And the definition of insolvency can be found in the Estonian Bankruptcy Act. And there are two kinds of insolvencies. And if insolvency is also asserted by the court, we have to do with bankruptcy. So if we have a company which is insolvent, but it's not declared bankrupt, we just have to do with insolvency. But on the other hand, when we have a company which is insolvent and also it has been declared bankrupt by the court, then we have to do with bankruptcy. Then in that sense, bankruptcy is a legal term, and that legal term is linked to insolvency. But to move on, then in order to talk about permanent payment difficulties, so also meaning bankruptcy, then it is also very, very important to know about the consequences of bankruptcy. Can you please put the next slide? Thank you. So in that sense, we need to differ between temporary and permanent payment difficulties. And in order to do that, we need to check always the Estonian Bankruptcy Act and also the case law. And there are actually two different kinds of insolvency definitions, and those can be found in Bankruptcy Act and also in the Estonian case law. But generally speaking, those definitions are everywhere actually pretty the same, because internationally it is known that you have actually two options. Option one, you have no liquidity, you have no money in order to pay the debts, or the other option is that you don't have enough assets to cover the obligations. So these are the main options when your company is insolvent. And that is the same in Estonia. And these situations are also described in the Estonian Bankruptcy Act. And according to case law, we can assume that a company is insolvent when the net worth of the company is negative. Then we have also to do with insolvency, and the company is insolvent. And if we have to do with insolvency, then it's also linked to the obligations of the management board. So if the company is insolvent, the management board has also filed the application to declare the bankruptcy, the company bankrupt. And there are some other consequences which are linked to insolvency. Can you please put the next slide? Yeah, thank you. So, as said before, then if we have to do with insolvency, the management board has the obligation to file for bankruptcy, and the Estonian Bankruptcy Act states that the management board has to file the application as soon as possible, but not later than in 20 days. And it also means that if that obligation will be infringed, then the management board will be liable. And being liable means that from the perspective of the creditors, if it would have been possible to satisfy the claims of the creditors in a bigger amount during the bankruptcy proceedings, as it is now, as the bankruptcy petition wasn't filed, or it was filed too late, then the management board has to compensate that difference or that sum to the bankruptcy estate. That is one side or one aspect that is linked to the bankruptcy petition obligation. But another one is when it is evident that the company is insolvent, then no payments are allowed which aren't in accordance with the interests of the company or with the due diligence obligation of the management board. And according to the case law, it means that almost all the payments are not allowed, and you shouldn't make almost not any payments at all, because afterwards, during the bankruptcy proceedings, it can be said that when you haven't made those payments, the claims of the creditors would have been satisfied in a higher amount. So in that sense, those payments could have harmed the interests of the creditors or the interest of the company. So the general rule is that there shouldn't be made any payments at all when the company is insolvent and the insolvency is evident. Okay. And also it's important that there is not only civil liability of the management board, there is also criminal liability of the management board. And it means that if there are made that kind of payments to some creditors, then later on it is possible to commence criminal proceedings against the management board, and it would then result in imprisonment or in monetary penalty somehow. So please be aware of it. And also there is a criminal liability for causing insolvency. It means that if insolvency is already somehow evident and you are still taking some kind of new loans or making some kind of payment which will only deepen the insolvency of the company, then you could also be liable for causing the insolvency of the company. That is also a very important thing to know regarding bankruptcy proceedings. But if there will be open bankruptcy proceedings, there are also very, very different options how to increase the bankruptcy estate. And it means if it's possible to increase the bankruptcy estate, it is also possible to make the chances higher of the creditors to satisfy their claims. And the first option is to file a lawsuit against the board, as already described before. And another option is to investigate those transactions which were made before the company was declared bankrupt. It means if there were any strange transactions, meaning that some kind of assets were going out of the company, some kind of property rights, or I don't know, other kind of property, whatever, then it is possible to revoke those transactions. And it's also possible that there was a kind of transaction and there was also an exchange, meaning that assets were going out of the company and there was also paid some kind of money to the bankrupt company. But then you have to compare if these values which were exchanged, if those were equal, or if you could compare them somehow. If it was evident that the value which went out of the company was very much higher than the value which came back to the company, then it is possible to revoke that kind of transaction. And that is also possible during bankruptcy proceedings. And in order to do that, the bankruptcy trustee has to file a lawsuit. And another option is also a lawsuit, but it's about the transfer of enterprise. It means if the bankrupt company went bankrupt, but the business activity was carried on in another company, so that the business went on, the employees were the same, the address of the company is the same, the management board is maybe the same or almost the same, and also the owners are the same, or they are somehow linked to the bankrupt company, then it is possible to file a lawsuit in order to assert that the transfer of enterprise has taken place. Then the court will assert that the transfer of enterprise has taken place. It is possible that those claims which were against the bankrupt company, that those will be turned against the new company. So against that company to which the assets have been transferred to. It's another opportunity how to increase the bankruptcy estate. I'm not saying that in all the cases it is possible, but each case is different, and in each case those circumstances have to be analyzed. And generally speaking, if most of the people think that bankruptcy is a dead end and nothing is to get, then in some cases it isn't that way. Always I advise to analyze the case, and if there are some opportunities in order to increase the bankruptcy estate, then those opportunities can be used. So it is always, okay, not always, but in many cases it is possible to increase the bankruptcy estate in order to make the possibilities of the creditors higher to satisfy their claims. But if to talk about liquidation of the company, then usually the bankruptcy proceedings will end with liquidation of the company, which means that the bankrupt company will be deleted from commercial register. And in that sense, we have to do with compulsory liquidation, but also it is possible to liquidate the company voluntarily. And it means that outside of bankruptcy proceedings. And in such case, the company owners, so the shareholders, have to make the decision that they would like to liquidate the company. And if there are no creditors who have any claims or who would like to file a lawsuit against the company, it is possible to liquidate the company. But if it's evident that some creditors are not in favor of liquidating the company voluntarily, then litigation procedures will follow, and it is not possible to delete the company from the commercial register. So I think that's all regarding bankruptcy proceedings. There are several options how to increase the bankruptcy estate and how to increase the chances of the creditors to satisfy the claims. But there are also reorganizations proceedings. If we don't have to do with permanent payment difficulties, and we have to do with temporary payment difficulties. As said before, there is no legal definition for temporary payment difficulties. So it is up to the company itself if it would like to solve its problems out of court and to make settlements with its creditors, or it would like to commence reorganizations proceedings. Both ways are okay, and it is up to the company itself if it would like to launch the other options or whatever. But talking about reorganizations proceedings, it is also very important to know the steps of reorganizations proceedings. If you would like to commence reorganizations proceedings, then really important is the cooperation between the creditors and also the reorganization advisor. It is not possible to be successful with reorganizations proceedings if there is no good cooperations between the management board and the creditors. And the reason is that during reorganizations proceedings, it is possible to file their claims or to appeal. And if you don't have good cooperations with the creditors, then they will file their claims, and they will also appeal. And it is really, really hard to get that reorganizations plan approved by the creditors and also by the court. And the court will approve the reorganization plan only then when it is approved by the creditors. But I will come back later to that question, how many creditors have to approve it. So why are reorganizations proceedings good? For whom and what is the point of it? The main point of it is maybe the reason that you can stop enforcement proceedings. If you don't have reorganization proceedings, it is not possible to stop enforcement proceedings. But if reorganization proceedings will be open, also enforcement proceedings will be stopped. And also it is not possible to open bankruptcy proceedings against your company. And also the calculation of interest and contractual penalties will be stopped. So those are the most important questions or issues. And also you can reduce or decrease the claims of the creditors during reorganizations proceedings. And if most of the claims can be reduced or decreased also outside of reorganization proceedings, then the claims of the Estonian tax authority, so meaning tax claims, can only be reduced during reorganizations proceedings. So if you have some tax issues, then during reorganization proceedings, it is possible to reduce your tax debt. So that's also a benefit of reorganization proceedings. But there are also some steps regarding reorganizations proceedings. If you would like to file for reorganization proceedings, then usually you have to justify in the application that after reorganization proceedings it is possible sustainable management of the company, and if you will be able to justify it, then usually also reorganization proceedings will be opened, and there is the deadline 7 days. It means that if you file the application, then not later than in 7 days you will get feedback from the court that reorganization proceedings have been opened or they haven't been opened. But mostly I must say that they will be opened. And then in the next stage, you have 60 days time in order to propose a reorganization plan in order to overcome your difficulties and in order to solve your problems. And during that 60 days, you also need to have the approval or support of your creditors. And there is needed 50% of the creditors who are representing the votes of 2/3 of the creditors. So it's a pretty high, how to say, amount. So it always comes back to the question or to the fact that you need to have a good understanding or cooperation with your creditors. No reorganization proceedings will be successful if you don't have the support or the approval of your creditors or of your main creditors. And if you have it, then usually also the court will approve your reorganization plan. And if there should be any issues, then the court usually will also involve experts to make expertise to say that that one or the other question is that way or that other way in order to be able to decide if the reorganization plan should be approved or it shouldn't be approved. But I must also say that the creditors have a lot of rights in order to file their complaints or to appeal. And it also means that sometimes the reorganization proceedings can be quite long. So if you would like to commence reorganization proceedings, then I would say that in advance you should talk to your creditors if they are really ready to support your reorganization plan, because afterwards it could be really difficult, and if they are not in favor it, you could just, I will say, stay there with your costs and you have wasted a lot of time and a lot of money, and you have not been able to get the reorganization plan accepted by the creditors or by the court. But if everything goes well, then the reorganization plan will be also accepted by the court. And if it's happening that way, then we'll follow the enforcement of the reorganization plan. And it will follow then in accordance with the reorganization plan, and the court and also the reorganization advisor will observe it, so that it will really take place in accordance with the reorganization plan. So that was everything about reorganizations proceedings, but we have also something going on with the corona crisis. So there are some impacts which are also influencing the bankruptcy, bankruptcy issues or bankruptcy act. there have not been many changes, but the most important change is that the management board doesn't have the obligation to file for bankruptcy during the emergency situation and also 2 months after it, but all the other management board obligations will stay in force. And all the other management board obligations mean that no payments are allowed, which aren't in accordance with the interests of the creditors or the company. And generally speaking, it means that almost no payments are allowed. And still, if the company is insolvent and insolvency is evident, then nevertheless, the bankruptcy petition should be filed. But important is also that the creditors still have the right to file for insolvency. So the changes of the Bankruptcy Act have no influence on the creditor's right regarding to file for insolvency. Yes, that was all regarding the impact of the corona crisis. But we have also received a question from a participant of this seminar, and the first question was, am I able just reorganize one type of debt, since we would like not to want to include Swedbank debt? Yes, it's possible, because it is up to the company which will commence the reorganization proceedings, which creditors should be involved and which should not be involved. If you decide not to involve Swedbank, then it's okay, and it's in accordance with the Reorganization's, Proceedings Act. So it is allowed to leave out Swedbank. And the other question is, as we have 2/3, does this require voting by all the creditors? If you have 2/3, it means that all the creditors who have been involved in the reorganization proceedings, then they have to give their votes. If they are against it, if they are in favor of it, or if they say nothing at all, then the debtor company has to prove it during reorganization proceedings. So if you have 2/3 and the other party is voting against it or whatever, then you have to have a protocol about it. And if you have it, then you are okay, and probably you won't have a problem with it. So the third question is, what is process time approximately on this, and what is the cost of this? That is a really, really tricky question, because it always comes up to the concrete company, how many creditors there are, how many or what kind of contracts there are, what kind of assets there are. The bigger the company, the bigger will be the cost. But if it's a smaller company, then also the costs will be much lower. So I would say maybe 10,000 euro and maybe up to 2 years and not more. And that was actually all from my side regarding bankruptcy proceedings and reorganization proceedings. And now I would like to move on to the questions, if there are any, but I need to step a bit nearer in order to see the questions. But at the moment, I don't see any questions at all. So I'm very sorry for it. Maybe my presentation was so good, or if it wasn't, then please feel free to ask questions later on. You are free to call me or to email, and I'm always happy to answer your questions. But I would like to thank you for joining that webinar, and I hope that you will also join the webinars in the future. And I also would like to thank you, the Chamber, for organizing that webinar, and thank you very much for having me today. So thank you very much, and I hope we will meet again soon. Thank you.